Well, good afternoon again, and welcome to the Cornerstone Barristers seminar on development management pitfalls, given by me, Robin Green, and my colleague, Alex Williams. This seminar is going to look at three main topics. They are the implementation of planning permissions, the determination of reserved matters, and the discharge of conditions. And we're particularly keen to address potential pitfalls and issues that arise day to day when local authorities are dealing with each of these three topics. We have disabled the chat function, but there is a Q&A function. And if you have questions or queries about any of the topics we're going to discuss, please do let us know. And at the end of the presentation, we'll attempt to do them justice. This seminar is being recorded. The presentation, the slides, will be made available with the recording to every one of our attendees. And so without further ado, I'm going to ask Alex Williams to start with the first topic, that of the implementation of planning permission.
Thank you, Robin. So topic 1 of 3, implementation, is quite an important one for developers and LPAs alike, I tend to find. I've found myself advising on it quite a bit in recent years. Now, why is it important? Overwhelmingly, the reason is the time limits that accompany a permission. It didn't always used to be the case, but every permission now has a default shelf life of 3 years attached to it, unless, of course, the LPA provides for another period. And very often it's important to know whether a permission has been validly commenced on time or whether it's lapsed. And this is made more difficult, perhaps, when developers apply perhaps for a lawful development certificate, certifying that they've done a fairly minimal amount of work, which has nevertheless commenced the permission. So overwhelmingly, it's for time limits reasons that this issue becomes important. And there are also related purposes for which an LPA may need to know whether a permission has been commenced. One good example is the recent case of Atwill, a New Forest National Park Authority. In that case, the developer applied under Section 73 of the 1990 Act to amend a condition relating, I think, to design in relation to a development. And the issue arose as to whether that permission had in fact been implemented. And the High Court held that ultimately it hadn't. And therefore the Section 73 application had no relevance. You can't amend a condition on a permission which has lapsed. Similarly, under Section 94 of the Act, for example, an LPA may decide that development's commenced but not completed, and it may wish to issue a completion notice. And so for that reason, an authority may wish to know whether and when a permission has been implemented. So ultimately, it's time limits, but this issue of implementation crops up in various situations. So what does it mean to implement a permission then? Well, the answer is given by Section 56 of the 1990 Act. Development is begun on the earliest date on which any material operation comprised in the development begins to be carried out. Section 56 then fleshes that basic point out in relation both to operational development and to material changes of use. In relation to operational development, we're told by Section 56 that there are 5 forms that may implement a permission. Firstly, any work of construction in the course of erecting a building. Secondly, any work of demolition of a building. Thirdly, digging a trench, which is to contain the foundations or part of the foundations of a building. Fourthly, laying an underground main or a pipe to the foundations of a building, or to any trench, which is to contain the foundations. And fifthly, any operation in the course of laying out or constructing a road or part of a road. So Section 56 gives quite a range of activities, of operational development activities that may amount to, a material operation. We're also told by Section 56 that where material changes of use are concerned, any change of use in the land which constitutes a material development can be a material operation. So the question arises, what's a material development? Well, section 56.5 answers that question, and we're told it's any development except 3 forms of development, which are then mentioned. The first is development for which planning permission is granted by a development order, so GPDO, or a local development order, or a mayoral development order. The second is development which is mentioned in paragraphs 1 or 2 of Schedule 3 of the 1990 Act. That includes the change of use of a single dwelling house into multiple dwelling houses. And the third is any other development which is in a class which is prescribed under secondary legislation. I'm not aware that there is any such class, and so for present purposes, that third category is not really relevant. I tend to find, I don't know whether Robin finds the same thing, but I tend to find that these issues of whether permission has been implemented tend to arise in the context of operational development rather than changes of use. But do just remember that there are specific rules on changes of use and implementation, and that section 56.4 and section 56.5 provides for those. Now, what are the main principles when it comes to implementation? Perhaps the most important is that very little needs to be done to satisfy section 56. That issue is made clear by Malvern Hills, which is on the slide. In that case, the developer had pegged out a new road, a distance of some 250 feet, had driven pegs into the ground. They weren't intended to be a permanent feature of the development. And after pegging out the new road, poor weather set in and the developer couldn't do anything more. The question arose as to whether that constituted a material operation, and the Court of Appeal held that it did under what is now section 56.4d. It was an operation in the course of laying out or constructing a road. So even though the pegs weren't intended to be permanent, they nevertheless satisfied section 56.4, or the equivalent of section 56.4d. The quantum of work, therefore, is not really the issue. When an LPA has to ask itself whether work has commenced the development, it's not so much the quantum of work that matters, unless, of course, it's so minimal as to be negligible. What matters more than anything is whether the work is actually comprised in the development, and that's a point I'll be coming to in a few slides' time. But that point is made clear by Thayer and the Secretary of State for the Environment. And just to give you a couple of examples of work which inspectors have found satisfies the requirements of section 56, we can see that work is fairly minimal. So in one case, an inspector found that a permission for a housing development had been validly commenced by the digging of a trench that was just over 2 meters by a meter. So what would look to be fairly minimal, but nevertheless is enough to satisfy section 56. And in another case, the digging of a hole for foundations that was no more than a cubic meter, that was still enough to satisfy section 56. So it's not about the quantum of the work so much as whether it's comprised in the development. Now, 2 potential pitfalls just to be aware of in relation to 2 of those forms of operational development that are mentioned by section 56. The first is foundations. Under section 56, it's the digging of the trench that constitutes the material operation. So the trench doesn't need to actually contain the foundations for the building that's permitted. It just has to be a trench for the foundations. And also it only has to be for part of the foundations. And that means, of course, that it's unnecessary to actually get as far as laying the foundations themselves. It's the trench that constitutes the material operation. But also it means that even if the trench is then backfilled, that still constitutes a material operation, because it's the trench. A developer is free to backfill the trench having dug it. And of course, many developers may want to backfill the trench that they've dug for safety reasons. In particular, if there's some lapse of time between digging the trench and carrying out the rest of the work, developers will want to make that safe. So even if the trench is backfilled, that still constitutes a material operation. Secondly, in relation to drainage, do remember that it's the laying of a main or a pipe that constitutes a material operation under section 56. It doesn't have to be both. And that pipe or main has to be either to the foundations or to a trench which is intended for the foundations of the building. And that means that the laying of a main or pipe can amount to a material operation, even if the foundations or the trench don't yet exist. And that's made clear by the Spackman case from 1977 in the High Court. And one inspector has also taken the view in an appeal, which is I've referenced on the slide, that a pipe which is laid doesn't even need to touch the foundations or to come right up to the area where the foundations will be. It's acceptable for a developer to leave some space so that the pipe is not damaged when the foundations are eventually laid. So what matters is whether the pipe work is to the foundations, but not necessarily right up to the foundations. That can still constitute a material operation. It's also important to remember that a material operation has to be comprised in the development according to section 56. The most important thing that both developers and LPAs can therefore do is to check the approved plans. It's not the case the digging of any old trench or the laying of any old pipe work will do. The works have to actually be comprised in the development which is permitted. And so if they're not reflected on approved plans, then generally speaking, they won't constitute a material operation. A material operation also can't be in breach of a condition, especially pre-commencement condition. And that point's made clear by Leisure Great Britain and Isle of Wight Council. Now, we do talk in a bit more detail later on about the discharge of conditions. But it'll be known to you that many planning permissions contain pre-commencement conditions that require details to be submitted to and approved by the LPA before development begins. What happens if a material operation takes place in breach of those pre-commencement conditions? Well, generally that creates problems for developers. Because of the 3-year shelf life, there's something of a countdown, and developers are sometimes under a race against time to make sure that all their details are approved before they begin work. And in some cases, they may get as far as applying to discharge these pre-commencement conditions, but those pre-commencement conditions may not actually be discharged by the time the work takes place. So what happens in that situation? Well, generally speaking, the work that the developer carries out will not amount to a material operation. But there is an exception to that principle, which is spelled out in Whitley and Sons and the Secretary of State. In certain situations, even though work takes place in breach of a pre-commencement condition, it may be irrational for the LPA to enforce against the developer for carrying the work out in breach of condition. And if 4 conditions are met, then this exception under the Whitley case arises. So if the developer makes their application to discharge a pre-commencement condition before the work begins, if the LPA later grants that discharge application, even after the work takes place, if the LPA doesn't enforce against the developer in the meantime, i.e. between that date of the work taking place and the application being granted, and if the developer carries out the work according to the details which are eventually approved, then in that situation, if all of those 4 conditions are met, it will be irrational for an LPA and therefore unlawful for an LPA to enforce against the developer. And the result is that the developer's work will have validly commenced the permission, even though the LPA hadn't actually discharged those pre-commencement conditions at the time of the work. So the general rule is that development has to occur consistently with pre-commencement conditions, but there is an exception if those conditions under Whitley are established. Now, this also gives rise to the question of inconsistent permissions. There's nothing to stop a developer applying for permission for a site which is inconsistent with another permission. There's nothing to stop a council from granting inconsistent planning permissions. But difficulty begins to arise when a developer carries out work under one permission, which renders it physically impossible for another permission to be implemented. In that situation, that other permission will die. And that's the point established by Pilkington and the Secretary of State. Now, that case is now some 50 years old, but it was recently glossed and explained in greater detail in the Supreme Court case of Hillside, It would be remiss of me not to pass over to Robin at that point to tell you a few words about, or to say a few words about Hillside, because he was in it. So I'll hand over to him now.
Alex, thank you very much indeed. Yes, I was in it. All I will say is that my client came second. Yes, Hillside Parks. In 1967, planning permission was granted for a large scheme of development, 401 dwellings laid out in an estate with estate roads and so on a hill in Abu Dhabi in Wales, which just happened to be in a national park. The ground conditions proved to be challenging, and very quickly the developer applied for certainly one permission to carry out somewhat different development when beginning the scheme of development. And that was the pattern that was then followed as ground conditions proved difficult, as the developer's plans perhaps changed or evolved. Applications were made to the local planning authority for subsequent permissions for development on discrete parts of the site. And the local planning authority was perfectly happy to grant them, and it was the understanding of both the local planning authority and the developer that in other parts of the site where the discrete subsequent permissions didn't apply, the developer could still rely on the 1967 permission. But that all changed in 2017 when the local planning authority said, actually, because you've carried out development pursuant to the subsequent permissions that's different from what's shown on the master plan, you can no longer rely on the 1967 permission. So what happened? Well, the developer sought a declaration from the High Court that it could rely on the 1967 permission. The High Court was unimpressed, refused the declaration. Court of Appeal followed the High Court. This then went to the Supreme Court, where a number of arguments were advanced as to why the 1967 permission could be relied on. None of those arguments proved attractive to the Supreme Court. It's a very helpful decision, although obviously unhelpful to my client, but it's a very helpful decision that it does clarify a number of points of law relating to the implementation of permissions, particularly inconsistent permissions. As Alex has made clear, in Pilkington, it was decided that development under one permission can render it impossible to carry out development under another inconsistent permission. And applying that, the Supreme Court said here that the subsequent permissions granted by the local authority, and more particularly the carrying out of development pursuant to those subsequent permissions, meant that it was no longer possible to carry out the development permitted by the 1967 permission. So that's a reaffirmation of the Pilkington principle. The Supreme Court also made clear that where you have planning permission for schemes of development involving two or more buildings, then that is going to be construed as planning permission for a single scheme of development, unless the permission says otherwise. It was argued in Hillside that the permission in question was for essentially 401 acts of individual development. And the Supreme Court said no, construing this as an ordinary permission for a scheme of development, it permitted one scheme of development, which could not be divided up in the way the developer would like to divide it up. And that's likely to be the case for, frankly, every permission for multiple buildings, unless the permission says otherwise. And that's, I have to say, pretty unusual. Okay, I will now pass on to Alex again.
Thanks, Robin. So we come to topic 2 of 3, which is reserve matters. Now, just as a recap, reserve matters relate, of course, to outline planning permissions. What is an outline permission? Well, in essence, it is a grant of planning permission with certain matters held over for approval by the local planning authority at a later date. Section 92 of the 1990 Act gives a definition of outline planning permission, and that definition is then fleshed out further by the development management procedure orders relating to England and Wales. Now, crucially, both of those orders make clear that outline planning permission may be granted only for the erection of a building, so not for changes of use or even for other forms of operational development. And reserve matters are also defined in each of these orders. In the English order, they're defined as any of the following matters in respect of which details have not been given in the outline planning application. It then lists those matters: access, appearance, landscaping, layout, and scale. Each of those terms is a term of art, and each of those terms is further defined in the order. There's a similar definition of these terms in Wales as in England, except there's a fuller reference in the Welsh order to scale. Matters of scale are said to be scale within the upper and lower limits for the height, width, and length of each building, stated in the application. Contrast that with the simpler English definition: height, width, and length of each building. So some slight variations, but those definitions are broadly the same in England as in Wales. Now, the grant of outline permission doesn't stop a local planning authority imposing other conditions on development. But it's important to remember that those conditions are precisely that. They are conditions. They're not further reserved matters. And that point is made clear by the Court of Appeal in the Murray case, which is on the slide. That case involved the grant of outline permission, and to that outline permission there was attached a condition concerning off-site mitigation measures. In that case, the developer had 3 years from the grant of permission in order to have reserve matters approved, dealt with, and 5 years in total for development to take place. And the court has to ask it, or had to ask itself in that case, this condition in relation to off-site mitigation measures, which time limit applies? Is it the time limit relating to reserve matters, or is it the 5-year time limit relating generally to conditions? And the Court of Appeal held that it was the latter. So it is open to a local planning authority to impose conditions, even on an outline planning permission, but do just remember that they are conditions and they're not further reserve matters. As we've seen, reserve matters are specifically defined under each of the Welsh and English development management procedure orders, and those are the definitions that LPAs need to work to. Now, I've just trespassed on the issue of time limits, and on that, I'll hand back over to Robin to say a few more words.
Alex, thank you very much indeed. Yes, time limits. As is now well known, reserve matters applications must be made within the period specified in the permission, and the default period is 3 years if no period is specified. The failure to submit all the reserved matters details for approval within the time limit is clear, it's stark. The outline permission will not be capable of implementation after that point. Next slide, please. As for the form of application for the approval of reserved matters, in England, it's, at least in theory, a little looser. The application must be in writing and include the necessary particulars, plans, and drawings to deal with the matter that's been reserved. In Wales, they take a little more formal approach. There is a form, a prescribed form, that must be used. But in essence, again, the relevant particulars now set out in the form must be provided, and the plans and drawings, as are necessary, must also be given. And both articles in the English and Welsh orders require a certain number of copies to be provided. Although in England, as I say, an application could be made in writing in the form of a letter or something of that sort, there is actually a form on the planning portal for applications. I suspect most local authorities have forms as well. So although in theory an application could be made in the form of a letter or email, something of that sort, in practice, I suspect most local authorities receiving reserved matters applications receive forms, whether they're in England or Wales. The position in England and Wales for non-compliant applications is the same. If a reserved matters application does not comply with the relevant requirements of Article 6 in England or Article 4 in Wales, that is not a valid application. And the local authority can refuse it as such, or can indicate to the developer that the application needs amending or supplementing if it is to be determined. As for amending reserved matters applications, in a case now some vintage in Inverclyde, the House of Lords made it clear that when dealing with reserved matters, local authorities have to act flexibly. This isn't an area that calls for technicality or a pedantic approach to applications. And therefore, it's only right that developers should be able to amend their applications, which may mean supplementing them, even if the time limit for applying for approval has expired. But the House of Lords did say that there is a limit to this flexibility. If a reserved matters application goes in for 4 out of 5 reserved matters, the 5th one having been omitted, and the time limit then passes, it won't be open to the developer to amend the application to include details relating to the 5th matter. That would be to go further than mere amendment, and that simply isn't permitted. Along with the Inverclyde case, the case of Heron Corporation made clear that any number of reserved matters applications can be made up to the date of the time limit set by the Commission. So the fact that reserved matters approval has been given once doesn't prevent a developer from making one or more further applications if it wants different reserved matters to be approved. So, as I say, this is an area where local authorities are expected to act flexibly, subject, of course, to the time limit that applies. Once that time limit falls, no further applications can be made, although some amendment will be possible. Next slide. As for the substance of reserved matters, it's fair to say that the outline planning permission binds both the local planning authority and the developer. So far as the developer is concerned, that means that any reserved matters application must be within the scope or ambit of the outline planning permission. And in determining whether an application is or is not within the scope or ambit of the outline permission, you need to interpret the outline permission correctly first. You may need to interpret the application for reserved matters approval. And then it's a question of fact and degree, or planning and judgment, whether or not the application is within the scope of the outline planning permission. One of the older examples of a case where the reserved matters application was not within the scope was that of Castle Point District Council and Brooks. In that case, outline planning permission had been granted for a bungalow. Then along came a reserved matters application seeking the approval of details for a large house. And the High Court said the house is not what had been permitted by the outline permission. Not only does the outline permission set the scope of what the developer can do, the outline permission also establishes the principle of development, and therefore the local planning authority is also bound by it and can't go behind it. The position was made perfectly clear in the case of Paul Newman New Homes Limited, essentially saying that once the outline planning permission has been granted, the local planning authority is bound by it and can't, at the reserved matters stage, seek to revisit matters that have been fixed by the principle of the outline permission. And so an outline permission, even if it says nothing about the quantum of development, must mean that some development is permissible. And so you can't, at the reserved matters stage, perhaps feeling a sense of seller's remorse, seek to prevent any development going ahead because you now regret having granted outline permission in the first place. That simply isn't permissible. Some outline permissions will specify the amount of development that can be carried out. Some won't. If the outline permission does fix the quantum of development, and that could be by way of reference to floor space or number of units to be built, then the local planning authority cannot insist on a smaller quantum of development being permitted at the reserved matters stage. And I've referred to two authorities there. The Newbury case, that concerned a floor space limit. Village Concerns was a little different. And if we can go on to the next slide, we can see that that sets out, in summary, what Village Concerns was about. That was an outline permission for up to 205 dwellings. And until the Village Concerns case, there hadn't actually been any authority on whether or not that permitted a local planning authority at the reserved matter stage to cut down the number of dwellings that could be provided. Having gone through the authorities, Mr. Justice Dove held that they could not, in granting outline permission for up to a given number of dwellings, the local planning authority had accepted through the grant of permission that that number of dwellings was an acceptable quantum of development. And so a local planning authority can't refuse reserved matters approval in the hope of reducing the number of dwellings to be permitted. What it could do is say that if, for example, the layout for up to 205 dwellings was not acceptable because the layout wasn't the best that could be achieved for that number of dwellings, then it could refuse the application. But what it can't do is, under the guise of dealing with reserved matters, seek to cut down the quantum of development that can be built out by the developer. Reserved matters, as I've indicated, the general rule is once a local planning authority grants outline permission for a quantum of development, or at least for the principle of development, it can't go behind it at the reserved matters stage. But there is one important qualification to that, and that's where either the habitat regulations or the EIA regulations apply to the development. If it turns out at the reserved matters stage that there are likely to be significant environmental effects that, for whatever reason, haven't been taken into account already, either because no EIA or appropriate assessment was carried out, or because those assessments didn't actually identify those particular effects, then it may be necessary to carry out either a further or supplementary EIA or appropriate assessment. And it may be, depending on the results of those assessments, that reserved matters approval would have to be refused. So that is one important exception to the principle that outline planning permissions determine essentially the principle of development. As for the imposition of conditions, as I think is now well established, when granting reserved matters approval, it is open to a local planning authority to impose conditions on that approval. And that's, well, it was implicit in section 78(1) of the 1990 Act, which gives a right of appeal against the imposition of just such a condition. And it was made clear that that is the case in the High Court in Newbury and in the Court of Appeal in Fulford. An important qualification, of course, if you're going to apply conditions to a reserved matters approval, those conditions must relate to the reserved matter being approved. You can't, at the reserved matter stage, use this power to impose conditions to impose the sort of conditions that should perhaps have been imposed at the outline stage but weren't. Finally, non-material changes. As you will know, under section 96A of the Act, there is a power on application for local planning authorities to make non-material changes or amendments to planning permissions. And in Fulford, the Court of Appeal made clear that that power also extends to making amendments to approval of reserved matters. Alex, I think it's back to you.
Thank you, Robin. That brings us on then to topic 3 of 3, which is discharging conditions. Now, I think each of us has touched on this before, particularly in relation to implementation, but it's a topic in its own right. Now, every planning permission comes with at least one condition attached. Broadly speaking, a condition may do one of three things. It may require something to be done of a developer. So a classic example is the submission of details for approval. I talked about that in relation to pre-commencement conditions and implementation. Those conditions are known as positive conditions, conditions that require positive steps by the developer. A condition may also prohibit something from being done. A condition may, for instance, prevent a new building from being used for any purpose other than that which it is intended for. Those are known as negative conditions. And thirdly, a condition may regulate the use of land or the carrying on of operational development over time. So a condition may, for instance, impose times or impose limits on when during the day building work can take place. A condition may regulate the use of a land, one example being, for instance, a bar or a restaurant in a hotel. There may be restrictions on operating hours for that bar or restaurant for amenity purposes and for the benefit of neighbouring properties. And when we're talking about discharging conditions, as we were discussing with topic 1, we're usually concerned with the first kind of condition, a condition that requires a positive step or steps to be taken by the developer. And the condition can be said to be discharged when those steps and the condition's requirements have been met. Now, there are formal requirements, as with applications for reserve matters, there are formal requirements attaching to applications to discharge conditions. And these are set out in the English and Welsh Development Management Procedure Orders, which have broadly the same requirements. An application has to be in writing. It has to identify the planning permission in question, and it must include such particulars and be accompanied by such plans and drawings as are necessary for the LPA to deal with the application. So it's incumbent on a developer to anticipate what it is that the LPA needs in order to determine the application and to include that information in the application. If it doesn't do that, if the LPA feels that it needs more information from the developer, then it's open to the LPA to request that further information. And again, it's incumbent on the developer to meet the LPA's needs because it runs the risk of the LPA rejecting the application if there isn't enough information for it to be satisfied that the condition should be discharged. Applications to discharge conditions must be determined within the statutory 8 weeks, which is set out in each of the English and Welsh Development Management Procedure Orders. It's open to a developer and the LPA to agree a longer time period in writing. And that, of course, begs the question, what happens if the LPA doesn't determine the application within the relevant time limits? And on that, I shall pass back over to Robin.
Thank you very much indeed, Alex. In 2015, the government was in one of its sort of pro-development frames of mind. It seemed to go back and forth depending on whether you're a Shire Tory or not. And it decided that it was fed up with local planning authorities, as it saw it, not determining a discharge of condition applications quickly enough. At the time, it said that there were about, I think, 1 in 3 discharge applications not determined in time. So it introduced Section 74A, in England only, I hasten to add, into the Act, which provides for the deemed discharge, not of all conditions, but of certain conditions, if the local planning authority has not determined an application seeking its consent, essentially an application seeking discharge of a condition in time. And the conditions for this to apply are that the applicant has applied to the local planning authority under Article 27, which is the article dealing with applications generally for the discharge of conditions, that a deemed discharge notice has been given to the local planning authority by the developer under Article 29, and the earliest the developer can do that is 6 weeks after it has made the application for discharge, and that the local planning authority has not given notice of its decision in time. The deemed discharge notice will set a time limit, a minimum of 2 weeks, for a decision to be given. And if the local planning authority doesn't give it its decision in that time, then under section 74A, the local planning authority's consent to any of the matters required by the condition in question is deemed to have been given. So if a local authority is unable to determine a discharge application in time and a deemed discharge notice is given, it may find itself bound essentially by the details in the application, whether it would have been satisfied as to those details or not. Now, that's potentially quite serious because conditions are imposed out of necessity, and the idea that a developer should have deemed consent across all conditions, no matter what they cover, was obviously of some concern. So the government has provided a list of exemptions to the deemed discharge regime. And if we go to the next slide, we can see what they are. As one might imagine, EIA development and development that could affect a qualifying European site is not subject to the deemed discharge regime. Likewise, flood risk conditions, development within and likely to affect a SSSI, contaminated land conditions, archaeology conditions, highway access conditions, and reserve matters conditions are all excluded from the deemed discharge regime. So if a deemed discharge notice is served on you as local planning authority, do be careful, do check to ensure that it is actually in relation to a condition that is subject to deemed discharge under Articles 28 and 29. I should just add that at the moment, biodiversity gain conditions are not exempted from these provisions, but the proposal is that the section 74A is going to be amended in due course so that biodiversity gain conditions are also exempted. So watch this space. As to consultation, well, the general position is that there is no duty to consult on applications for the discharge of conditions. The Secretary of State could impose a duty on local authorities to consult, either publicly or certain individuals. No such duty has at present been imposed. But again, do be aware of circumstances that might require consultation. Certainly, I know of at least one local authority that has come unstuck because its statement of community involvement said that it would consult neighbours affected by discharge applications, and its failure to do so meant that it was acting unlawfully, and an approval of details under a condition was quashed by the High Court because there had not been consultation in accordance with the statement of community involvement, notwithstanding the fact that there is in fact no statutory duty to consult. So just do be aware of that. Record of reasons. If a decision is taken by an officer, and of course most discharge decisions are taken at officer level, then the Openness of Local Government Bodies Regulations 2014 are likely to require a record of the reasons for the decision to be made and published. There is no definitive ruling on whether or not those regulations apply to all planning decisions discharging conditions, but I think the safest course is to assume that the regulations do apply, and if conditions are discharged, a record of the reasons for the decision should be made. I think that covers the slides anyway, and I can see that there are two question and answer responses. I'm going to read the first one. I've been asked to alter an outline description of development from 56 dwellings to around 56 dwellings to provide flexibility. I think this is too imprecise. What are your thoughts? Well, obviously we can't give detailed legal advice, not in a forum like this, but I can understand your concern, because around 50 dwellings is imprecise. It's less precise than up to 50 dwellings or up to 56 dwellings, which might be a better formulation. I think what matters is that you, the local planning authority, are clear what it is the outline permission is permitting, understanding that whatever is permitted, you are binding the authority to accepting that quantum of development. So, as I say, I can understand your concern about that. Alex, any views?
No, well, not beyond what you said, Robin. I don't think I've seen an outline description with that language before. It tends to be up to, I'm not aware of well, as I say, I haven't seen an application that says around 50 dwellings. I think again, without being able to give advice, I think my gut view would be the same, that is possibly imprecise, and that it gives rise to concerns on the local planning authority's part. It has to be satisfied that it's giving outline permission for something that is sufficiently clear. So that may be an issue to consider.
Yes, you can grant an outline planning permission without specifying the quantum of development, but if you do want to specify or at least limit it, then the wording should be sufficiently precise to do so. Otherwise, you're just making problems for yourself further down the line at the reserve matter stage, because if an outline permission is granted for around 50 dwellings and reserve matters come in for 55 dwellings, well, is that around 50 dwellings or not? As I say, I share your concern. The next question is, how would it be possible for a local planning authority to require additional matters to be formally reviewed at outline stage within 1 month from validation by virtue of section 5.2 of the Development Management Procedure Order? Would it be necessary for the local planning authority to justify the use of these powers for additional matters to be formally considered? Could the applicant's disagreement to provide these additional matters details lead to a reason for refusal? That's quite a detailed question. All I will say is this: there are, if you like, limits on the additional information that local authorities can require from developers in relation to planning applications. An application for the discharge of conditions is not a planning application, and my tentative view, and it's just an off-the-cuff response, is that those limitations don't apply to discharge of condition applications. And if a local authority considers that further details are necessary to determine those applications, then it has every right to ask for them and can refuse the application if they aren't provided. That's, as I said, that's my very tentative view, based on a superficial assessment of the question. Again, Alex, any particular views on that?
Nothing to add. I wouldn't want to hazard a guess, and mine would be similarly tentative. I'll defer to your
fair enough. Perhaps I shouldn't have hazarded a guess at all, but anyway, I'm trying to be helpful. Can a condition to remove permitted development rights, e.g. extensions, be put on a reserve matters application, or must it be on the outline? How would such condition relate to the reserve matters in question? I think that's the critical question. I can see circumstances might arise where, for example, a particular layout is thought crucial, and you wouldn't want to allow changes to the layout, so you might be tempted to impose such a condition at the reserve matter stage. But I think it would be said against you if you want to remove permitted development rights. That's something that really ought to have been done at the outline stage. I can see arguments either way. Again, this isn't really the place for detailed legal advice. I'd say it's arguable that you can impose such condition at the reserve matter stage if it relates directly to the reserve matter being approved. Alex, any views?
No further ones on that, actually, Robin. No.
And then finally, with regards to prior approvals for additional flats above existing blocks of flats, are there any examples of what might constitute commencing the prior approval permission? For example, would exploratory work to check if the building can take the weight of the flats, for example, drilling into the roof of the building, as well as the erection of scaffolding and storage of materials on the roof, I suppose, count as commencing the prior approval permission? Alex, I'm going to hand over to you on this one and see what your instinct is.
Yeah, my instinct is that it's important not to stray beyond what Section 56(4) tells us about what a material operation is. I'm not aware, I haven't looked specifically at this point, obviously. I'm not aware that the rules on what constitutes a material operation are any different for prior approval and permitted development permissions than they are for the standard permissions. So I think my gut view would be that merely exploratory works, checking that the building can take the weight of the flats, drilling into the roof of the building probably wouldn't be enough. And so that's my gut view on that particular issue. I think it's important to stick to what Section 56(4) tells us, and not to stray beyond that.
Alex, with respect, I agree. I think it must be comprised in the development, and if it's prior to that, if it's not development or works within the development, then that wouldn't be enough. So I share your view on that. I would just make this point. The intention with which works are done is irrelevant to ascertaining whether or not they are capable of commencing the permission. That's been made clear in a number of High Court cases. The fact that works are carried out just, if you like, to preserve the permission and not to carry on the development is neither here nor there. If the works themselves are comprised in development and they're not de minimis, then that's enough. I'm happy to say, I think that, the penultimate question, the penultimate question we have, and we're going to have to call it quits soon, but the penultimate question is, will this recording be provided after the meeting? Short answer is yes. This recording and the slides will be provided to all those who indicated they wanted to take part in the seminar. And the last question, nutrient neutrality and prior approvals, i.e. condition in the 2017 regulations by operation of law, would it be a breach of condition notice or enforcement notice, i.e. the condition goes to heart of development? When you raise the issue there, does a permission go to the heart of the development? That's not something that one can determine as a matter of generality. In the Hart aggregates case, either Mr. Justice Sullivan or Lord Justice Sullivan, as he became, indicated that the Whitley principle applies only where the condition in question goes to the heart of the permission. Whether it does, it seems to me to be a matter that will be very much fact specific. So I don't think it would be proper to express a view in relation to that question.
And the seventh question is not a question so much as a statement. Thank you very much. Very useful seminar. Thank you. And actually, there's an eighth question which has come in now. Oh, no, it's a statement like question 7. A really helpful session. Thank you very much. Thank you to the sender of that comment.
Yes. Well, thank you all very much indeed for listening to us. We hope this has provided some useful information about development management matters. I would just say as a plug that there will be further words of wisdom from members of Cornerstone Barristers at our planning day, which is going to be held on the 6th of November. And we hope that some of you at least will be interested in coming along to that, details of which can be found on our website. As I indicated earlier, this recording and the seminar slides will be made available to all those who indicated they wanted to take part. And I would just say thank you very much indeed for taking part.
Thank you, everyone. Take care.